Good evening, everyone. On behalf of the Free Library of Philadelphia and the Social Science and History Department, I would like to welcome you to this evening's program. Without further ado, let me introduce you to our guest host for this evening, Deborah Gross from Pennsylvanians for Modern Courts.
Great. Thank you, Maria, very much. And thank you for the Philadelphia Free Library for this series of programs that we PMC have been putting on. I am the CEO of Pennsylvanians for Modern Courts, and we will talk, I guess, as you see a PowerPoint. A few things. If you have any questions, please put them in the chat, and we will get to them. This program is being recorded, and further, it will be recorded, so it will be available on our website, and we will be able to share with you after the program the slides that we are going over. So Anaya, do you want to share? Thank you. Okay, great. So first, again, I want to thank the Philadelphia Free Library, but I also truly want to thank our presenters, Judge Jennifer Schultz and David Sonenshein, both of whom are, I'll say, repeat offenders for our program, for PMC's programs. Judge Schultz has actually gone with PMC into the classrooms to teach about the courts and the judiciary. She is currently a Court of Common Pleas judge sitting in the criminal division, and David Sonenshein is I can't even explain this, but a world-renowned awarded professor at Temple Law School, and not only teaches law students, but teaches, police, teaches many different constituencies about criminal law and evidence. So thank you both for joining us. Go ahead, Anaya. So there is a QR code on the screen right now. It is very important to us that you put your phone up to the QR code, complete the survey, because we get funding from foundations based on how many responses we get to the survey, and and information about our participants. So we'll have the survey up now for another couple seconds, but we'll also show it at the end. And I truly thank you for completing the survey. Okay, Anaya. If you have any technical issues, please email us at staff@pmconline.org, and also know that our website has a wealth of information about many different topics, so please feel free to visit it. Thank you. PMC was created over 30 years ago to help ensure that that Pennsylvanians could come to the courts with confidence to be heard by qualified, fair, and impartial judges. We have expanded, I'll say, our mission to increase the focus or increase our attention on educating people about the court system, about the law, understanding how the judiciary works, understanding the rule of law in our state. Thank you. Keep going. So we do a lot of different kinds of work, as I briefly said before, but we talk about we have and I'm saying this because if you are interested, we have a court watch program where we rely on community volunteers to go into our courts in Philadelphia. We go into the preliminary arraignment court and the early bail review hearings. We observe, and we, at the end of a certain time period, we actually issue reports, and we work with the judges, the various parties, on improving the system. So if you're interested, please reach out to us. Go ahead. And these are upcoming programs that are all virtual or hybrid, actually one in person in Pittsburgh, but you are welcome to attend even if they're not in Philadelphia County, because they cover topics that relate to law across the state. Okay. And this is what we will be talking about today. We'll be talking a little bit about the Pennsylvania court system. I'm going to go through that very quickly, and then what to expect in court, the procedures, the participants' rights, and the criminal process itself. Okay. Your Honor, do you want to talk about this a little bit?
Sure. So do you want me to just pick up from here and go?
Sure.
Okay, I'm going to use my version of the slideshow, if that's okay. So I'm going to do my screen share.
Okay.
All right. It says I have disabled screen sharing.
Okay, let's figure this out. Huh. Anaya or Mariha, are we able to share?
Are you a co-host? Because if you're a co-host, you should be able to share.
I believe I was. The link I used said that.
You're a co-host now, so you should be able to share.
All right, let me see if I can make this work.
Great. Perfect.
And then we have. All righty. Okay.
Awesome.
So thank you so much, Deborah, for that lovely introduction. It's great to be here this evening. I know we have people joining us from different places. I'd love to know where everybody is from. I think you have access to your chat feature. If you just type in where you're from, I know we probably have a lot of Philly folks, but I'm also interested to know what other parts of the state might be joining us. So please feel free to share that in the chat. So the Pennsylvania court system is made up of a series of different courts. They have this great diagram that explains it. And so I'm in this second green tier, the Court of Common Pleas. And so it's called Common Pleas because the idea is that it is going to be the court of general jurisdiction. So if you're going to have a problem with family court, or if you need to sue somebody for a car accident, or if you're being charged with a serious crime, the Court of Common Pleas is where those matters are going to be heard. Below the Court of Common Pleas, we have a series of courts in Pennsylvania that are of lesser jurisdiction. So they're minor courts. They have more specialized roles. In Philadelphia, we have the municipal court. Also in Pittsburgh, they have a municipal court. The rest of the state has magisterial district judges. And that's where you're going to do small claims court, landlord-tenant issues, and a lot of the warrants are going to be decided by those magistrates or municipal court judges and things like that. And then above the Court of Common Pleas, you have two different kinds of appellate courts, and they are responsible for hearing different kinds of cases. The Commonwealth Court is responsible for hearing administrative appeals. So if you have an appeal over workers' compensation or something like that, that's where that will wind up. It also deals with questions involving tax issues, as well as other questions about how to, that a lot of kind of this structure of the Pennsylvania government. The Superior Court handles most of the other appeals. So appeals on criminal matters or civil cases and things like that are going to go to the Superior Court. Then we have a Supreme Court in Pennsylvania. That is an appeal level. After you've gone through that second layer, the appellate courts, you can ask for the Pennsylvania Supreme Court to hear a case on a second level of appeal. But for most cases, it is something that the Supreme Court decides which of those appeals to hear. And so that's kind of the general structure of our court system. All right. Okay. So the Philadelphia criminal court system, as I said, we're going to hear, so we're going to have the municipal court is going to hear the traffic court dispute. So if you have a parking ticket or a speeding ticket, you're going to be a municipal court, or out in the outside of Philadelphia would be in front of a magistrate. A lot of the criminal cases may begin in the arraignment stage. In the preliminary hearing stage will be heard at the municipal court level, and then later those felony cases get sent higher. Okay, so when we're talking about criminal cases, there's three major buckets to think about. We have summary offenses, misdemeanors, and felonies. Summary offenses are going to be those very minor infractions. Oftentimes they don't involve any kind of an arrest, although that is an option. So things that you'll see in the summary offense category will be disorderly conduct or shoplifting, minor dollar amounts, criminal mischief, or perhaps in Philadelphia, possession of small amounts of marijuana. And then misdemeanors are going to be your less serious criminal cases. That might be things like simple assault or, other kinds of things in that realm. And they tend to be, and they can have up to 5 years imprisonment attached with them. But many times you're looking at much more minor sentences that go with those misdemeanors. And then everything else, the larger crimes are called felonies. And there are different categories of felonies. And those are the cases that the Court of Common Pleas focuses most of its energy on. Okay. All right. So when Pennsylvanians for Modern Courts called me and asked me to speak, I thought about what is it that people want to learn about the court system. And I thought about how people interface with the courts. And the experience that you'll have inside of the court system will be different depending upon what your role is. And so I wanted to talk a little about that from the perspective of how you might interact with the courts, specifically the criminal court process, because that's the topic for tonight. So a few kind of general rules. Hats off. So just a reminder, I know people like to wear hats a lot of places, but it is still expected that they be taken off, and gentlemen will often be reminded to remove their hats when court is in session. Of course, there is an exception for religious attire. So if that's the reason a person's wearing a head covering, they are allowed to keep that on. When court is in session, people need to not be speaking, even if they're in the gallery. The expectation is that the room should be quiet. There's also no cell phone usage at all. So it doesn't matter if it's silent. You cannot have the device on at all. And this is something that the court system takes very seriously. In fact, it's actually a crime to record or photograph anything that's going on in the courtroom. And they are very concerned about issues around witness intimidation, but also maintaining the integrity of the court. So it's really one of those places you have to turn your device off completely and put it away. And if you don't do that, they might take it from you. Okay. So I wanted to explain a little bit about how the courts work, because it is a bit different than other parts of our the way that we function in our society. One of the key features is that we have a duty to be impartial, and that applies to the judges, but it also applies to all of the court staff as well. And when we mean impartial, we can't appear to be leaning to one side or the other. Our job is to stay neutral, to kind of start from that even scale idea. And so in doing that, we can't appear to be too helpful to one side or another, because that would threaten that impartiality issue. So think about, like, if you're, a defendant, how would you feel if the judge is super buddy-buddy with the plaintiff, with the prosecution? And so that's why, part of our job is that we have to kind of, we have to keep some distance between us and the participants, both inside of the court and outside of the court. Sometimes people can interpret that as being cold or even sometimes rude, but it's really not intended in that way. And sometimes, and this also, these rules apply to the court staff. So if people are asking for help from somebody in the clerk's office, they're going to be limited in what they're allowed to do for you, or even what information they can tell you. And again, it's often because they're trying to maintain that impartiality. They can't be too helpful. And it's helpful when everybody understands that starting point. Like, we're not trying to be difficult. It's just, we have to maintain that boundary for everybody's benefit. Some of what that means is that the people shouldn't be talking to a judge except in the courtroom. So you can't call a judge up at in their office and tell them what you want them to hear about the case, or tell them, hey, my son's having this problem. He can't get in touch with his lawyer. Can you help him out? We can't take those calls. We can't hear those things. And it's not that we don't want to help. It's just that the rule is we're not allowed to have what's called ex parte communications. Ex parte meaning without one of the parties. And so the way that we maintain that rule is that people communicate with us in the courtroom when everybody's present. And additionally, you can't send a letter to the judge because it still has that problem of being ex parte. So the way that you communicate with the court or with the judge is by filing the paperwork with the clerk's office. And that's the official record that is accessible to everybody. But in order to file documents, you have to be a party in the case. So if you're a family member, you're not going to be able to submit paperwork or communicate by writing with the court. And again, it has to do with, you have to be a party who's recognized as part of the proceeding. In addition, the jurors, people who are serving as jurors, have this same responsibility to remain impartial. and to not appear to be having any kind of contact with anyone. And so it's never appropriate to talk to a juror. So if you're ever on jury duty and they make you wear those little badges that say juror and there's those bright yellow stickers, that's why we ask people to wear those stickers. It's a great way for us to see very easily that person's a juror. I need to steer clear. And if you're another person who's participating, a family member or somebody else, it's also a signal that you should respect as well and steer clear of that person who's a juror.
Your Honor, I just want to interrupt you for 1 second. Oh, jury. Okay, you got jury duty. Don't worry. Go ahead. I'll be quiet.
Okay. All right. So speaking of juries, so hopefully this is the reason that you're interfacing with our criminal system. You get one of those summons that says you've got to come to jury duty. So I want to give some people some pointers on what you might experience in jury duty. And also, as we're going through this, feel free to put any questions in the chat. I'd love to answer questions as people go. So when you get called for jury duty, expect that there will be a lot of downtime. It sometimes feels like, why are they wasting your time? Because you're just sitting in a room, and sometimes that can be for hours. And then you go up to the courtroom, and then they send you away for lunch for 2 hours. And then you come back and you wait another hour. And it feels like it's kind of wasted. I assure you, though, we are not sitting there doing the crossword in the meantime. We have a lot of other steps to the case that we have to take care of. And we are working as fast as we can to keep those things moving. But it's a good idea, if you have jury duty, to plan for that downtime. Maybe bring a book or a magazine to occupy yourself. Also, there may be times where you're not allowed to leave. They'll give you lunch breaks and things, but there might be a lot of time where you have to be waiting and you can't leave and go out somewhere. So it might make you more comfortable if you have a drink or a light snack in case there isn't enough time for you to get something. A lot of the jury spaces do have vending machines available to people, but you also have the option to bring your own things. Once you are selected to be a juror, they will take your phone away, and your computer and your smartwatch, anything that's internet enabled. And again, the reason for that is that we want people to not be getting distracted while they're hearing the case, but also during deliberations, we don't want people to be doing any kind of outside research. The jurors are supposed to make the decisions based on the information that was in the courtroom. And so as a safeguard, we take those devices away during the daytime. When you get sent home for a night, you get to take your devices with you. The other thing is that if you're a juror, you'll find that you're often escorted around the building by one of the court staff when you're in these groups. And again, that's to preserve that impartiality and to make sure that other people are not interfacing with you when they're not supposed to. Lastly, a lot of times the jurors won't get a lot of detail about what's happening when they're not in the room. And particularly, the judge may ask you to step out after this, somebody says objection, and then you come back in the room and all you get told is objection sustained or overruled. And the reason for that is that the law actually says we're not supposed to let the jury know everything. There are certain things the jurors are not supposed to hear because we don't want to prejudice the case. And so you're not always going to get a lot of information, and you just have to kind of be okay with the fact that you don't get to know everything. So the other thing is they feed you while you're deliberating, but not during the trial. But if you have a deliberation, that's a whole day deliberation, it's very common that a lunch will be provided by the court system. In Philadelphia, we are still in a masking policy for people in the jury process. And that is with the understanding that it is a large group of people that we're bringing into a space, and we want to keep everyone safe. So at least in Philadelphia, for the near future, you will still be asked to wear a mask in those times. Okay, so a couple of the rights the jurors have. You have a right to not be discriminated against based on a protected class, right to receive reasonable accommodations if you have a disability. And we do work very hard to try and provide as much accessibility as possible. I've had jurors come in who have sign interpreters or mobility issues. Sometimes we may change locations where somebody sits in the jury panel to accommodate hearing issues or other health issues. We try very hard to be as open as we are able to be. Now, for the most part, your name and your image and other identifying information are not made available to the public. However, when you fill out your juror sheet during the jury selection process, your names are made available to the participants in the case. But other than that, those documents get destroyed. Also, when if you take notes during while you're watching the trial or deliberating, those things get destroyed and they're never revealed to anybody. Okay. So what do we ask of you and jurors? Please show up when you get that subpoena. Subpoena actually means under penalty, subpoena, it's Latin. And so, it's not often that those get enforced, but it's not a request. You got to come to court, got to come to jury duty. And we do ask that you be on time. Throughout the process, you're going to be asked a lot of different questions. Telling the truth makes that go a lot faster, and you are under oath when you're answering those questions. Most crucially, what we need from every single juror is to be fair and impartial, to be willing to keep an open mind, and also to not talk about the case until it's over, even with your family and friends. Once the case is over, that changes, but again, to make sure that you're not being impacted by outside influence, you can't talk about the case while it's going on. And lastly, I want to wait and not make up your mind until it's time to deliberate. And when you are deliberating, of course, you're going to consider the ideas of your fellow jurors, but ultimately every juror makes up his or her mind in the process.
Your Honor, are there age limits for jurors?
No. Well, okay, so you have to be 18.
Right.
So it's not, so you have to reach that initial starting point.
Right.
But once you're 18, you need to be a citizen of the United States, and you need to be able to read and understand the English language. So those are kind of the crucial elements that we need. And hearing can sometimes be a barrier. People need to be able to understand what's going on in the courtroom, to be able to understand the evidence, to be able to understand, so people giving testimony, or if there are documents or photographs or videos. But as long as people have those abilities, beyond that, there are no like set restrictions. Okay. So moving on to defendants. Defendants are going to be required to appear every single listing. And because this is criminal cases, if a defendant doesn't appear, often that can result in a bench warrant. Similarly, you can't just show up and then leave. You have to wait until your case is called. And until the judge dismisses you from that proceeding. Typically, the next court date will be set at that time, and you'll be required to sign a subpoena acknowledging that new court date before you can leave. Sometimes you might not have a lot happen when you're there. So we make you show up, your lawyer stands up and says, defense request, they're given another date, and then you're done. And you're like, wait, what happened here? But that process is how your but that process is how your attorney represents what's needed, and so but there is stuff going on even though there's not a lot said in the courtroom. Most of the time the judge is not going to address the defendant directly, and that's to be respectful of the fact that you have a right to remain silent. So it's not trying to ignore you from the process. We are trying to make sure you protect your rights in that moment. Usually, if you want the judge to know something, you should tell your attorney, and then they can communicate it to the judge. Sometimes judges will allow defendants to address the court directly. It depends on those circumstances. And if you feel strongly that you want to be heard, you should ask politely for that opportunity. Okay. Sometimes the defendants may have to be sworn in. Typically, that's going to be if there's a colloquy where there's a point where there's a decision that the defendant has made, and we want to make sure that the record is clear, that the defendant is understanding what rights they have and how the decision they're making is impacting those rights. For instance, if a defendant is choosing to plead guilty, I want to make sure they understand what that means to plead guilty and what they're giving up by that process. That's when we're going to ask for a defendant to be sworn in. Okay. So the other things that people can see when they have a defense attorney is lawyers may be very, very busy, and court is typically not going to be your opportunity to have a long, complex conversation with your attorney. So if your lawyer is not able to spend that time with you at that moment, ask them, okay, I understand you're busy. When can we talk? Find out when you can make that call or have that next appointment with them if that's something that you're looking to do. Your lawyer may also come to you and say, I have an offer, and then they tell you what the Commonwealth is offering. Sometimes people get taken aback by that because it might not be a very good offer. And they're like, why are you even telling me this lousy offer? The answer is that the lawyer is required to transmit to their client every single offer. So it doesn't mean that your lawyer wants you to take that offer. It just means that they're letting you know about it. Then you can talk with your lawyer and ask, what should we do here? You may also notice that a defense attorney might seem to be friendly or cordial or even joking with the prosecution. And some people take that to feel like that means their lawyer isn't on their side. But I would encourage you to look at that a different way. So lawyers, they interact with each other all the time in the court space, and they develop relationship and rapport with each other. And that having that relationship and rapport can actually benefit you when your attorney is trying to advocate on your behalf. And so that's why it's not necessary that your lawyer has to be at loggerheads with the opposing counsel to still represent your best interests. Okay. So I think we all know these. You have the right to remain silent. But when you hear that in the Miranda warning, we think of that most of the time with the police. But that right to remain silent carries with the defendant throughout the whole proceeding. So that means that if a judge is asking the defendant questions that could impact that right to remain silent, they don't necessarily have to answer. Again, you should check with your lawyer, but that's also why the judge typically doesn't communicate with the defendant directly, because we're trying to respect that right to remain silent. In addition, you have a right to remain silent at a trial. So the defendant is not obligated to testify. The Commonwealth cannot make the defendant take the stand and ask them questions. And the finder of fact, the person who makes the decision about guilt and innocence, either the jury or the judge, if you've waived your right to jury trial and asked for a judge to decide your case, whoever's making that guilt determination is not allowed to hold it against you if you choose not to testify. And again, that's because of that fundamental right to remain silent.
Judge, if I can interrupt for 1 second.
Most definitely.
On the right to remain silent, as a former defense lawyer many, many years ago, I can tell you that probably the hardest decision the defense lawyer makes is whether to have his client testify or not. As the judge just told you, of course, correctly, defendant doesn't have to. And there are lots of reasons why a lawyer says, I don't want my client to testify, and lots of reasons why it would make sense to testify. And just to appreciate that if the defendant does testify, what that means is the jury, for example, can hear about his or her prior record. And that can be very prejudicial. And so the lawyer might say, well, we're better off if they don't hear about that because we don't want people to judge you based on your past. At the same time, we worry that if you don't testify, the jurors might say to themselves, well, why did he get up there and say he didn't do it? And so it's a very difficult decision. I think probably the hardest one that the defense lawyer has to make. And in the end, it's the defendant's decision.
Thank you so much for that.
Sure.
Okay, so then you also, as a criminal defendant, you have a right to an attorney. And if you cannot afford one will be appointed for you and free of charge. And you also, embedded in that is a right to represent yourself. And getting into the right to an attorney, I've added the word here, competent. And there's a lot of case law that gets into what does competent mean. But one of those fundamental issues that we're concerned about is making sure that a person's attorney is actually serving in the role of the advocate that they're supposed to and achieving that goal of competence. You are presumed innocent. And that means that you are innocent until the Commonwealth proves beyond a reasonable doubt that you have in fact committed the crimes that you've been charged with. You do not have any obligation to prove that you are innocent. The Commonwealth is the one who has to prove the elements of the crime. And that means also that you don't have to put forward any evidence to try and prove your innocence. You don't have to, all you have to do is sit there and your attorney can cross-examine the witnesses, can make argument, but there's no obligation to present any evidence and no obligation to testify if you don't want to. But you do have the right to present evidence in your own defense if you want, and to testify in your own defense if you want. And those are all of those different decisions that Mr. Schoenstein was talking about.
So, Your Honor, there's an interesting dilemma, right? When a defendant wants to represent him or herself, you have to go through a serious questioning, I will say, of the defendant as to why he or she wants to represent him or herself, and what this means. There's also a question in the chat about, can you fire your attorney even if they are free? You can always fire your attorney. But there is a concern that representing yourself can be more harmful. Do you want to explain a little bit about the process that you have to go through?
I mean, we could do a whole hour on that. All right, let me answer the question. Can you fire your attorney if they're free? Kind of, sort of. So when you say free, I think you mean court appointed. And if you have a court appointed attorney, you would have to ask the judge for a new attorney, and the judge has to make the decision of whether or not that's an appropriate thing to grant. And some of the considerations are, how many times have you asked for this before? Because some people may, every time they come into court, they want a new lawyer. And we don't do that. The other factors are, will this significantly delay the case? If somebody's been represented and they've been represented for a year and a half, and on the day of trial, they say they would like a new attorney, we can't just get a new attorney and do the trial that day. So we have to balance all of those different factors when considering those kinds of requests. And we also have to look at why you're requesting a new attorney. Is it because this attorney isn't helping you, or this attorney, isn't responding to your communications or something, versus you just don't kind of trust this person, but you can't really say why or point to anything. And so all of those are the factors that we look at when there's a request like that. If you've hired an attorney, you always have the right to fire your attorney. But again, when you're firing an attorney, what's coming next? Are you going to hire somebody else, or are you going to represent yourself? And again, those same questions come up about what is that? How does that impact the progress of the case? So if you say to your judge, I want to get a new lawyer and I want time to go do that, and it's on the day of your trial, that may not be a request that the judge grants you. So then, you could fire your attorney, but the judge may say your trial's today. One way, so those are the different factors the judge has to consider when those requests are made. Let's see, in terms of representing yourself, the issue is that the court system is a very complex system, and there are all of these really complicated rules about how you present evidence, about what evidence is allowed to be presented, about how you go through all the different steps of a court process. The law is complicated in asserting your rights around issues of suppressing evidence and all the other issues that may come up in a case. And if you choose to represent yourself, the court still holds you to those same standards. And that can be, for many people, an insurmountable barrier to representing themselves. If somebody wants to do it, and if they're competent, the law says we can allow you to do that. But it may put you at a disadvantage, and it may prevent you from getting the full benefit of the rights that may exist, because you may not know how to ask for those rights and to assert those rights in the way that the court system requires. Do you want to add any more to that, Mr. Schoenstein?
No. I think, the Supreme Court said you have a right to represent yourself, but I think 99% of the lawyers would say that's a silly thing to do. And it usually does not go well. And very few people do it. Very few people do it.
Okay. Okay. And so I see that a follow-up question about the court-appointed attorneys is, how many times can you get a new one? And there's no rule that says you get 2 or you get 5. It's really going to be about the specifics of your situation, the reasons that you're asking for a new attorney, and the discretion of the judge, and how it impacts the flow of your case. What I would say is, if you have a court-appointed attorney and you want a new one for whatever reason, the sooner you make that request to the judge, the better. You don't want to wait until your day of your trial and say, oh, wait a minute, I've had this problem for 6 months. Because the judge is going to say, you should have asked 6 months ago. So you want to bring that request as soon as you're able to. Okay. Okay. There we go. All right, I'm going to move this along a little bit. This is all available in the PowerPoint that I think is going to be made available on the website as well. But this is the host of different rights that you have. Remember, I was talking about all those different special rules. This is a list of those rights the defendant has. I do want to talk a brief minute about friends and family of the defendant, because I think that people have a lot of frustration sometimes about their inability to participate in the criminal process. And the reason for that is that you're not viewed as somebody who has standing. The people who have standing in the case are the Commonwealth, the victim to a certain extent, and the defendant. And that's the world of people that the court will recognize and hear from in a case. So family and friends, they can come to court, they can watch what's happening, but for the most part, they're not going to be allowed to be heard in the court, or they're not going to be able to file papers. Let's see. And sometimes if you're a witness, you may be a friend or a family member and you want to support the defendant, but if you're a witness, either for either side, then they may tell you to stay outside of the courtroom. And that's a concept called sequestration. And that's to make sure that witnesses aren't hearing things and changing their story. They want those witness memories to stay pure to their original memory. Let's see. The other thing you have to understand is the defense attorney represents the defendant, and he has a duty to keep things confidential. So while you may want to talk to the defense attorney and say, what's going on? Why is the Commonwealth doing this? The defense attorney may not speak with you because his relationship is with the defendant, not with those friends and family. And that's true even if you're the one paying the bill. And I know that can feel a little weird, but the rules that lawyers have to follow are very clear on this point. And so they can only share with you those things that their client allows you to share.
And you know what? I'm going to interrupt you on thing because it's really important, because if the lawyer shares with you information and you are not the defendant, but you are some other party, that information is now no longer privileged and can be available to the opposing side, to the court. So it's really important that the lawyer be able to maintain the attorney-client privilege with the client.
Right. And that's true, particularly if if you let a third person in the room when the attorney and the client are talking, that destroys that privilege and it makes that whole conversation potentially subject. So I'm just going to briefly go through this. For family, if they feel frustrated, the docket is a public record. They can get information there about when the next court dates are, or if they want to see what's being filed in the case. If you're a friend or family member and you're helping to pay the bill for that defense attorney, you want to understand up front, how is this working? Do you have an obligation to pay? Have you agreed to a contract to pay? Or are you basically just giving the defendant money and they're paying? So you want to understand those things up front. Okay. I do want to talk a little bit more about victims' rights. There's been a lot of new laws in Pennsylvania over the last 5 or 10 years that have created a series of rights for people who are victims in criminal cases. If you are somebody who's identified as a victim in a case, and this is most particularly for cases involving crimes against a person, like an assault or something in that realm, you want to make sure that the DA has your contact information. You often will see that the DAs will change at different phases of the case. You'll have a different attorney handling it. And you're going to be asked to go to several different proceedings: a preliminary hearing, there may be a motions hearing, and then the trial. And so there's a whole host of different rights that attach when you are identified as a victim in a case, depending on the kind of crimes that are charged. And so you have a right to know about different things as they progress. You have a right to be heard by the court before there's a change on bail. And you should get notices about anytime there might be a bail hearing. And so the way that we're doing this in Philadelphia is that we are doing automated calls three days in advance to the victim identified in the file, so that they get an automated call letting them know there's another court date, which means it's possible the defendant could ask for a change in bail. And we want to make sure people know, so if they want to be heard on that issue, they can be in court and be heard. Okay, so a couple of these rights have some asterisks by them, and that's because you actually have to affirmatively say, I want that to hear about that, if you want those particular rights to be honored. But you do have a right to be heard before the sentencing, or essentially at the sentencing hearing. You can submit written comments if you don't want to go in person. And let's see, and okay. So again, if you want your rights as a victim, you absolutely have to make sure you're reachable. And the way that gets into the system first is by you giving the contact information to the police. And if you give your information to the police, that will then get passed along as it goes through the court system. Then the DAs will have your contact information and the courts will have your contact information. And you'll then be able to get these different notices that we were talking about. If your contact information changes, make sure you update the DA's office so that they can stay in touch. The other thing is, if you know that there's a court process happening, you want to make sure that you're paying attention to your phone. You don't want to ignore messages. Things can happen very fast. And if you're not responding quickly, you might miss something important in your ability to be communicating with the DA's office. Okay, so witnesses, I know I'm running late on time, so I apologize for going fast. Often, like, there will be many, you'll ask to come to different proceedings. So remember, if you get a subpoena, you have to show up. That's a requirement if you get a subpoena. If somebody asks you to testify as a character witness, that's a personal choice unless they subpoena you. Again, any witness is going to be asked to stay in the hall. That's a concept called sequestration, and that's for the purpose of making sure that your memory is kept clean and not polluted with the other information being talked about in the courtroom. Okay, if you have so the right to remain silent applies to any person having the right to not answer questions that could potentially incriminate themselves in a crime. So if you're a witness and they start asking you about what you were doing on X day, and the answer is, well, I was stealing a car, that's something that would incriminate you in a crime. And so you don't want to have to answer that kind of a question. So even though that might not be the subject of the case, if there's an answer that has the potential to subject you to criminal responsibility, it's something that you could say that you don't want to answer because of the Fifth Amendment. But if you're in that zone where you have a concern about that, the court will usually give you an attorney so that you're able to make those informed choices and correctly assert that right. In addition, the law protects witnesses against threats. It's a crime for people to threaten you or harm you to keep you from testifying, or in retaliation if you do testify. That's called witness intimidation. And if you think that you're experiencing that, that's something you should report to the DA or the judge. We take those issues extremely seriously, and we want to address those because that undermines our entire justice system. Okay, and that is my part. Thank you.
Thank you, Judge Schultz. Okay. Anaya, do you want to put back up or?
Yeah, well, you know,
I can put it back up.
I don't need the slides.
Okay, go ahead,
All
David.
right. I wanted, I appreciate what the judges told us. That's incredibly important information for you, the public, getting involved in trials. And that's something, of course, we depend on. I want to see if I can clear up three things that most of us who are not lawyers, I guess that doesn't include me, that most people who are not lawyers might misunderstand from watching television. First of all, the vast majority of cases, criminal cases and civil cases, don't actually end up in a full jury trial. The very large preponderance are settled, civil cases settled, but in criminal cases, a guilty plea or some other arrangement between the prosecutor and the defense lawyer to get rid of the case, if you will, take it away so the jury doesn't have to decide it and let the judge do the sentencing. Often those are, I shouldn't say often, they're always done by agreement. And it's almost sort of like a contract negotiation. And if we didn't do that, I'll just tell you, there wouldn't be enough courtrooms, judges, prosecutors, or jurors in the world to try all the cases we have. So number one. Number two, when you see on television after a big trial, all the news people are out there and the defense lawyer comes out. Remember, the government cannot appeal a criminal case. Defense lawyer comes and says, we're going to appeal. we're going to appeal and it's, we're going to win, et cetera, et cetera. Be appreciative if you are involved in a jury trial as a witness, as a defendant, as a whatever it might be. What you decide, as the jurors decide, is pretty much it. Winning criminal appeals is not the most likely thing that's going to happen to you. The vast majority of appeals are affirmed. Convictions are affirmed by appellate courts. So lawyers like to talk about, oh, I'm going to appeal, et cetera. Sometimes they do, and sometimes it does cost a lot of money. But the fact remains, most of the time, those appeals do not win.
And David, I guess
Yeah,
I'm just going to interrupt you because a lot of appeals are done by pro se, right? They're done from by prisoners in the prison. The court in Pennsylvania gets a lot of appeals that way, both in federal court as well as state court. That's
correct. There are post-conviction relief appeals, if you will. We'll use the word appeal, which gives the prisoner the right to pro se by him or herself file papers with the court, and the court has to consider them. I won't pretend that most of those are successful, but they are available, and so that is something that people can do. The one other item I'll just mention is to remember now that prosecutors are elected in Pennsylvania. Judges are elected in Pennsylvania. Many states that is not true. New Jersey, it's not true, for example. And so those elections that we hold for judges and prosecutors are very, very important. In the United States, prosecutors have essentially absolute discretion as to whether they charge you with a crime or not. And so the person who makes that decision, who's elected by you as the prosecutor, is an extraordinarily powerful person. And so you really want to participate in those elections to make sure you have the right kinds of folks making those kinds of important decisions. Final thing I'll just mention. We've talked about a number of people, defense lawyers, et cetera, prosecutors, just to be aware of the judge's role. The judge is like an umpire or a referee. The judge's job is to call balls and strikes, if you will, when the lawyers object, et cetera, or to, in the end, to give the jury instructions on the law, since the jurors are lay people. Other than that, in the American system, the lawyers are pretty much in control of the room. So don't be shocked if you don't hear from the judge all that often in the course of a trial. The judge is actually doing the right job by letting the lawyers try the case.
And so the other thing is that you may, when we get to a trial, right, you're going to hear a lot of objections, and a lot of that is also to preserve the record, right? And that's a really important part of a trial, is understanding, the record and making sure it's preserved. David, do you want to?
If I can just add to that point, there are two main ways to get to bring an appeal, two main reasons or bases to make an appeal. And they are: one, the judge makes an error in ruling on those evidentiary objections, and it's a serious error, number one, or the judge makes a mistake in instructing the jury on the law in a way that really is harmful to the defendant. Those make up, I would probably suggest to you, the majority of criminal appeals, plus one other item, and that is when there's a motion to suppress evidence because the police obtained it illegally. That can be a game changer. It often is a game changer, and that is often a basis for an appeal as well.
So, David, since we have a little bit of time left, and I guess instead of going through the process, do you want to talk a little bit about motions to suppress?
Yeah, I mean, these come up essentially in three situations: search and seizure, confessions or interrogations and confessions, and then eyewitness identifications. And the U.S. Constitution, as well as the Pennsylvania Constitution, have laid down rules to try to avoid getting unreliable confessions, trying to avoid getting unreliable eyewitness identifications, and trying to make sure that your right to privacy is secured from the police obviously breaking down your door and coming in and searching your premises for no reason. If you, as a defendant, believe any of those rights were violated, you then bring a motion to suppress in front of the judge, not necessarily the trial judge, but in front of a judge who will then decide, if the police didn't have probable cause or a warrant, then I'm going to throw what happened in that search out. The evidence is thrown out. And that's to sort of deter the police from doing that again. That could well end a case. The court can also say, I don't think that confession was properly obtained. I'm not going to let the jury hear that. Often the case goes on anyway because there's other evidence. And with eyewitness identifications, again, the same. Often the judge, or I shouldn't say often, from time to time, judge says, I'm sorry, I don't like the way that lineup was conducted. I'm not going to let the jury hear that information. And again, it might end the case, or the government may have so much other evidence, then in the end, it doesn't matter.
Okay. Your Honor, do you want to add to anything about the motions for suppression? Is that well, okay, so I'll put it this way.
Yeah, I mean, I hear them. Well, actually, it's
right.
interesting. I used to hear a lot of them. But the way that we're organized right now in Philadelphia is the jury trials are kind of queued up and ready to go, and then they get sent to me for the trial phase. So I'm hearing less of them now.
Interesting.
Yeah.
So, so it's a different judge that's hearing that?
Yes. And that's the current way that we have things organized, and every courthouse organizes itself differently. So
right.
It's hard to talk about this kind of across the state. But we run what's called a calendar system. So there's one judge who kind of tracks the cases, and then when they're ready, they send them out to folks like me, and so they kind of queue them up, and then we handle the trial part. I used to do more of those suppression hearings. Yeah, so I mean, I don't know. Did you talk about Terry stops at all? I don't think he mentioned. We
No.
talked about probable cause.
That's a good point.
Yeah, so probable cause is the standard for searches and seizures, but we also have a lesser standard that was established in a case called Terry, and so we call them Terry stops, and it's kind of like the quick the stop and search. And in order for a police to be able to engage with a person in that way, they need to have some kind of reasonable suspicion that criminal activity is afoot. And there's thousands of cases answering what exactly does that mean. What's really fascinating is that the Pennsylvania Constitution and our Pennsylvania Supreme Court has interpreted the protections of the Pennsylvania Constitution to be broader than the protections that we have under the federal Constitution. So if you're even in law school and you're learning about, all of the different cases that have come up through the United States Supreme Court, that's not actually typically going to be the cases that decide things in our courtrooms, because the Pennsylvania Constitution is often seen to give more limitations to the government intrusion and more protections to people's privacy in that context.
I'll just mention what the judge referred to as Terry stops, which is what we call them. The public may know as stop and frisk, or at least the stop may or may not end in a frisk as well. And again, as the judge said, you don't need probable cause for that, which you need for a full-scale search, but you need reasonable suspicion that a crime has been committed or criminal activity is about to be committed. You can't just stop as a police officer somebody on a hunch. You have to have something you can articulate. That's why I stopped him or her. That makes sense.
And there was recently, and you two can both correct me, a Superior Court decision that said you can't stop somebody just because they smell like marijuana. Right? I can't remember the name of the case, but I think it's in the past year. So, as you both have said, there has to be a reasonable suspicion that there is a crime that has been committed. So it's very important. Our slides talk about a lot about the process, and I'm not sure. We really don't have time. So there was one question in the audience. So first we'll send the slides. We'll discuss the process. It goes from preliminary arraignments to hearings to trials, to appeals, and it's there are slides that discuss each. And again, if you have any questions after you receive the slides, please feel free to reach out to PMC, and we'll be more than happy to answer any questions. There is a question in the chat about if it's a little unclear, so I'm going to let you two embellish it as to how you'd like to answer it. But if the opposing lawyer says information that was not revealed in discovery, what happens with that information? Can it be used?
David, you want to field that one?
Yeah. Yeah, I think I know where the question's going. There is a Supreme Court case called Brady, Brady versus Maryland, in which the Supreme Court said that the government has an obligation to disclose evidence that would exonerate or exculpate the defendant. That is evidence helpful to the defendant if the government has it in its possession. In other words, the government has a lot of resources. They have in the federal courts, they have the FBI. Here we have Philadelphia PD and all sorts of other investigators. And if they develop evidence and find evidence that would actually help, might sound odd, but help the defendant's case, they are supposed to disclose that. And if it's not disclosed, I will add that to my list of reasons why you might have an appeal if it turns out to be material and important evidence. There is not discovery in Pennsylvania in criminal cases as there is the same level in civil cases with pretrial depositions and all that kind of thing. So in the criminal side, we don't have that sort of massive kind of discovery from one side to the other.
Okay.
I think that's where the question was going, I think.
That's what I would think. So thank you very much. So again, this has been wonderful. I thank you both. I don't know if there's anything that additional that you want to add. I do think that everybody should realize that your participation in the court process is really important. And so, friends, family, if they get jury subpoenas, please make sure that they, attend and participate, because our system depends on our participation as individuals in this democracy. So thank you all for attending. Thank you all for presenting. I very much appreciate it. This will be available on www.pmconline. And Anaya, do you want to put up the QR code one more time, if possible?
Yes.
Thank you. And again, if you haven't had the opportunity to complete the survey, please do it. And at the end of the quarter, which will be March 31, we will award a Starbucks gift card from those who have filled out the survey. So thank you again, and have a great night.
Thank you.
Okay.
Great to be here. Thank you so much.
Thanks. Okay.